Reckless and criminal misbehaviour in the financial sector, of course, destroyed the Irish People's Pension Fund, exploded our national debt by a factor of 8 and inflicted untold suffering on the most vulnerable of our fellow citizens. And like the Greeks and Portuguese, we've had a lost decade, a decade of cuts and suffering. And it's particularly galling to citizens that only a tiny number of bankers have been held to account. We've had very few high-profile cases, such as the actions taken against Anglo-Irish executives Willie McAteer, John Bowe and Sean Fitzpatrick, and against Dennis Casey, the former CEO of Irish Life and Permanent. But as in the UK, the scale of the financial disaster was not remotely matched by prosecutions of those with responsibility. And by contrast, over the same lost decade in Iceland, the total number of senior Icelandic bankers sentenced for fiduciary and market manipulation crimes now stands at 29. And it was only last summer, I think, Cancórla, that the UK brought the first criminal case against a global bank chief executive when charges were brought against John Varley and 3 other Barclays executives. But the experience of Jonathan Sugarman, the risk manager at UniCredit Bank Ireland in 2007, and other banking whistleblowers clearly shows that we need fundamental reform of the Central Bank Act 1942 and of all subsequent banking regulation. I know you're familiar with the issues, Cancórla, that Mr Sugarman raised and the extraordinary way in which neither the Central Bank nor the Gardaí nor any other authorities investigated his complaint. So I'd like to warmly welcome the Central Bank Amendment Bill 2016 and to commend Deputy Pearce Doherty and Sinn Féin for bringing it forward. The bill, of course, significantly expands the powers of the Central Bank to conduct inquiries into suspected provision of false and misleading information, either deliberately or by omission, to the Central Bank by bankers and officials in the financial sector. It also provides for administrative sanctions and creates an offence of providing false or misleading information to the National Banking Authority. And Section 2 of the bill, of course, inserts a new Part 3D into the Central Bank Act 1942, which rightly provides for a summary conviction sanction of a Class A fine and or imprisonment for up to 12 months, or for a conviction and indictment for a fine of up to €250,000 and imprisonment for up to 5 years. These are very welcome provisions in response to the tracker mortgage fraud and the litany of banking and financial scandals and frauds over many decades. Since 2008 in particular, Cancórla, citizens, they have been rightly astonished at the apparent immunity for criminal misbehaviour in the banking and financial sector. People, for example, were first startled, I think, by the settlement agreement between the then financial regulator and Quinn Insurance in October 2008, when the regulator found serious breaches and contraventions by Quinn Insurance under the Insurance Acts, including failure to notify the financial regulator prior to providing loans to a related company. And of course there were fines, but constituents were very surprised that there were no court prosecutions followed in such a serious financial case. And they drew our attention in this House again to Part 3C of the 1942 Central Bank Act. Section 33AT, Part 1 of Part 3C, of course, lays down, as our colleague Deputy Boyd Barrett said, that when the regulatory authority imposes a monetary penalty, the financial, and I quote, the financial service provider or other person concerned is not liable to be prosecuted or punished for the offence under that law, end quote. And as a result, many citizens have complained that Ireland continues to have a separate legal system for bankers, which is administered in secret. I asked former Minister Michael Noonan whether he would amend or remove subsection 33AT1 of Part 3C of the 1942 Act, and he replied, of course, it couldn't be removed because it upheld the principle of, and I quote, ne bis in idem, or double jeopardy, and that therefore no criminal prosecution may be brought against a financial service provider or person concerned in the management of a financial service provider if the prescribed contravention in question has already been the subject of an inquiry under the administrative sanction procedure. And many deputies remember, in fact, and you remember yourself, Can, that when I was a Marine spokesperson and the administrative sanctions, we were trying to bring forward an administrative sanction for workers in the fishery industry, your former colleague Deputy Dempsey, he ruthlessly opposed it, and yet we have that system for the bankers. And last summer, just a final point, as the tracker mortgage scandal became more and more outrageous, I asked the Oireachtas Library and Research Service to prepare a paper entitled Legal Issues Relevant to a Proposal to Repeal Section 33AT of the Central Bank Act 1942. And the paper, of course, identified the double jeopardy rule, but the excellent study also refers to a recent decision of the High Court in Purcell versus Central Bank of Ireland, which says that a repeal of Section 33AT would not cause central bank inquiries and criminal charges in respect of the same acts to breach the rule of double jeopardy or ne bis in idem. So I commend again Deputy Doherty for this fine piece of legislation.
Thank you. Now